to suspect it's symptomatic of a greater animus that is just sort of soaked into the bones of the SEC to crypto, I think is a fair thing to draw from it. And it's just certainly consistent with everything else we're seeing from the SEC.
Hey guys, welcome to another episode of the Texas Blockcast. We are here today with Bill Hughes, Senior Counsel and Head of Global Regulatory Affairs at Consensus, aka the guy that handles all legal matters at Consensus. Bill, thanks for being on.
It's a pleasure to be here. Really enjoy the Texas Blockchain Council. I'm glad we're members.
We're glad to have you, and we're excited to have you at the summit as sponsors as well. You guys are coming out in November for that. So we have a very timely conversation today. There's a lot of stuff happening in the legal world with regard to several SEC lawsuits and some other lawsuits that we'll get into. But before we do, I want to get a little bit of background about you for the listeners, for the audience, for them to understand your professional background. So what led you to this current role, and give us a little bit of the history there.
I started to fall down the rabbit hole, as they say, back in 2017. I was working at the White House in an operational role, having just left the law firm to rejoin an old colleague and friend of mine who was asked to serve at the very beginning of the Trump administration. And I took this job. You have a lot more free time on your hands than you do at a private law firm when you do one of these jobs. So I started learning pretty rapidly about it and went from the White House to the Department of Justice. I did not really do anything with regard to crypto at Justice, but leaving Justice, trying to figure out the next thing I want to do in my life. The thought of going back to a law firm, just doing regular old securities litigation didn't enthuse me quite as much as it once did. I found myself reading a new issue of Wired, but one that republished an old article about the Silk Road investigation, arrest, and prosecution. And I realized reading it that, from my time in DOJ, a lot of what they're talking about with the FBI, about prosecution, about the sort of the federal law enforcement response to let's say criminal activity that involved digital assets, like I was much more familiar with that in my time at DOJ. The regulatory environment and the rulemaking process of the federal government was something that I was intimately acquainted with through those roles. And I thought it's early 2021, a lot of crypto companies, both those on the money side where you're dealing with investments and the tech side, you're actually building the technology. Both of them are recognizing how important regulations are starting to be. I had my background as a white shoe litigator who handled a lot of financial clients and banks and across the table from a lot of agencies, and I was just like my heart's in it. This is a field that fascinates me. I do believe that the future, this is going to play a very important role in lots of aspects of our economy, in our personal lives, our social lives. So I took a leap of faith and found Consensus very early, hit it off with them, and feel very, very lucky that I'm at the company I'm at.
That's awesome. I have to ask the white shoe litigator. I'm not familiar with that phrase.
Okay, so it is another term for big law. There is this, it goes back to this old notion that if you practiced law at certain firms, there was a certain dress code, and we're talking decades and decades and decades ago, long before you and I were alive for certain. But the term has stuck around to suggest a certain type of firm, primarily pertaining to the East Coast and the Upper Northeast and Wall Street and the like. So that's where I was.
Gotcha. That makes sense. Okay, well, we have a lot to dive into here, and I think we'll probably touch on some of those different pieces of your background, whether that's on the policy side at the White House or at the DOJ or as a litigator. But let's start with the most timely first. The recent Uniswap decision sounds like it was a class action lawsuit. Was maybe some similar rings and tones to the Tornado Cash challenge, where are you going to hold a developer responsible for some things that happened on a open source protocol? In this case, it was it's a decentralized automated market maker.
Mm-hmm.
Tell us how that case is. Well, tell us first of all what happened. What did the judge decide, and then
Yep.
what are the implications for that going forward with some of this SEC Coinbase litigation, securities litigation?
Sure. So in this case, a bunch of private plaintiffs took advantage of an opportunity in the federal securities laws to bring a private suit against another party. This is our federal securities laws obviously allows the SEC to sue you. They also allow, in certain instances, a private party to sue another private party. In this instance, they alleged that these plaintiffs had bought some ridiculous altcoin, which they probably shouldn't have been buying, and lost all their money in a rug pull, which means that the token value went to zero after essentially the creators of the token stole all their money and disappeared, because the creators and the issuers of this new token were anonymous and no one knew who they were. So given that they had a loss and nobody to go after, they went after Uniswap. And they not only went after Uniswap, the protocol and the protocol labs, they went after the investors who backed Uniswap and had put money into Uniswap, the protocol, essentially alleging like you built the platform on which this token was allowed to like have a pair, and therefore, for a number of different reasons, you should be held responsible for a loss. Among others, like these are you're responsible for, to some extent, providing an exchange mechanism or even issuing this scam token. This was brought in federal court in Manhattan, known as the Southern District of New York. As popularly noted, it is a very well-respected district court, which is the lowest trial level court in the federal system on issues of corporate malfeasance and especially securities law. SEC brings a lot of their cases in the Southern District of New York because the expertise that court has on these matters. So the judge in this case is actually the same judge who's hearing the SEC v. Coinbase case, and that'll be interesting in a second. But the defendants in this case, Uniswap and these investors, filed to dismiss the case, saying the allegations, assuming they're all true, do not allow this case to proceed because they're insufficient as a matter of law. And the judge agreed across the board. The judge noted that what was really happening here, some third-party scam artist used this platform to trick the plaintiffs out of their money and to defraud them. Because those particular perpetrators were not identifiable, the plaintiffs did the only thing that they could do and try to come up with a case to recoup their loss against Uniswap. And the judge says the securities laws do not permit you to do that under these theories. And one of the things, there's a number of notable things in the case. One, the judge notes that a lot of altcoins are ERC20 tokens. They're a token specification built on Ethereum. She's like, no one, whether or not these ERC20s are securities has not been determined by anybody with a competent authority to determine that. And included in that list are the courts and Congress. She doesn't mention the SEC as being a competent authority to determine that. I thought that was notable.
That's telling, yeah.
There was another comment of about tokens having, like, new tokens that don't necessarily have inherent value because they were created out of thin air, and how there's a distinction between, she identifies an implicit distinction between those tokens and tokens that do have inherent value, like Ethereum, which is notable. This is a federal court judge identifying a crypto token as having inherent value.
Wow.
Where in other contexts, especially, the brightest minds of the traditional financial world say that these things don't have an inherent value. But fundamentally, I'll wrap up with this. She makes a number of in pointing out that their case is flawed in meaningful ways, where even assuming everything they say is true, they don't have a case. She kept making the point that the federal securities laws don't place liability on the creator of a base protocol on which other people can engage in these tokenomics activities. So Uniswap, the protocol, is just there are legal uses of it. There's nothing tethering the Uniswap labs or any of its investors to the activity which caused the damage, and there's no theory under the securities laws which in this instance would make them liable for their damages. And that can change, but it would take an act of Congress for it to do it. Mm-hmm. And it's a long 53 pages. I'm still grinding my way through it again. But it's another in a long line of cases, in a growing line, I should say, which really casts doubt as to this incessant and antagonistic rhetoric from the SEC, which is an organization very used to having what it says being just deemed as law by everybody. And, the tide is turning in that regard, and I certainly believe that. And that's very good news for crypto.
It is. Let me ask, is this judge advanced in her career, or is she new to the bench? Trying to gauge, her age.
I'm not sure. I believe she was appointed by President Obama. Okay. I'm not sure at what stage of her career she was at, or really necessarily a ton of her background. You can easily look up the case and look her up. I'm hesitant to pronounce her name because I know I'm going to do it wrong. It's spelled Failla. So look it up on your own.
Sure.
The only thing I'll say is this: judges always have varying degrees of expertise as to any one particular area, and some judges are brilliant and pick up stuff very quickly and really know how to get to an issue, whether or not they're familiar with the subject matter. And some judges aren't. It's just like judges are just like people. There's this huge spectrum of ability, and some judges are known for being really, really, really sharp, and some judges just simply aren't. Again, no idea necessarily where you can place her on this spectrum, but I think because of where she sits in the Southern District of New York, there's that implicit deference to decisions out of there. It seems like a very thoughtful decision for my readings of it. And then I think the fact that it's another defeat for a theory that would be in line with the SEC's policies on this is particularly important. But I would look past the biography of these judges necessarily as to find some causal link between that and the outcome. I think it's quite simply the fact that the theory in this case, which is closely tethered to the theories that the SEC is propounding, are so disattenuated from reality and from how the securities laws work and from the way that new technologies are incorporated into our legal system, that courts are looking at this, and more often than not, unless they are quite happy, like some judges are, to completely defer to the SEC in almost every respect, they really scrutinize this stuff and say, no, this doesn't make sense. And there's a way to go about sort of creating order out of this chaos, and it involves Congress. So figure it out, guys. Yeah. And seeing that is certainly refreshing when that's what the crypto community has been asking for months, if not years.
Yeah, agreed. Well, Sohail here, who runs the studio, confirmed that she's sort of mid-career. He flashed up her bio for me here. So you're right. It doesn't really it shouldn't matter as to her age. Unfortunately, sometimes it probably does. But the merits of the argument are really where it should stand. And it sounds like we stand quite well on the facts and on the merits.
I will say, to your point, just like in everything, like you see it in Congress, you see it in the halls of these administrative agencies, you see it in courts too, and you see it in society. Let's say those further along in their career tend to have less interest in understanding what crypto ecosystems have to offer, what people advocating for them have to say. It's certainly, just like any technology, those who are on the younger side of society seem much more curious, much more excited about these things, and that manifests itself throughout. It's not an absolute rule, but that's how these technological waves happen. They're generally revolutions that are spurred along by the young. That's no different with crypto.
Absolutely. Well, let's shift a little bit to the other case that she's overseeing, the SEC v. crypto, or v. Coinbase, excuse me. It feels like it's SEC v. crypto. So the case SEC v. Coinbase, what do you make of these allegations by the SEC that Coinbase is operating an unregistered broker, clearing agent, exchange,
Yeah.
et cetera?
Yeah.
And also, can you distinguish those three things? Does it references broker, exchange,
Right.
clearing agent?
So the case says, I break the case up into three different buckets. There's one part of the case where they're alleging Coinbase for operating an unregistered securities exchange. And so basically they're saying some of the tokens on here are actual securities. And therefore, in order for you to create a market, to make a market in them, to create a two-sided market, to run an order book, you need to be a national securities exchange or something similar under the SEC regs. Part and parcel of that is like the fact that an exchange can't also be a clearing agent, can't also be a broker dealer. Like these different pieces, like these functions are broken up in the traditional markets for reasons like conflict of interest and other things. And they're saying, when you're registered as a national securities exchange, you can't also be these other things. And you right now are not only not registered, but you're performing multiple roles that the securities laws prohibit you from rolling. So that's point two. And that all has to do with Coinbase, the spot exchange, right? That's the app you pull up on your phone. There are two other aspects to the case which are very important too. The SEC alleges that their Coinbase's staking offering, where if you buy Ethereum or another proof of stake token, you can stake it on the platform. You could bring tokens off platform on the platform and choose to stake with Coinbase. And they have staking providers behind the scenes that do that, and you realize some of those staking rewards. They're saying that is a securities offering. And then the third is Coinbase Wallet, which is an unhosted wallet that's sort of built into the Coinbase app. Very, similar in some respects to the MetaMask wallet from Consensus. That wallet application is a broker dealer, meaning that it's a third party that is facilitating your person's transactions in securities. So those are the three aspects of the cases. And again, it's this judge in this Uniswap case who just put down the decision yesterday, who's the one overseeing this matter in the Southern District of New York.
So one of those, the wallet bucket, seems like quite a stretch. That doesn't even seem to pass the test of logic.
Yeah, the theory is that it's either the software program itself, and that offering that software program and maintaining it and updating it is the activity that should be the registrant, the broker-dealer registrant, who needs to be regulated pursuant to the securities laws, pursuant to FINRA rules, is the software developer who offers that software package. That is a completely novel theory, especially when that broker, that agent, or that software developer that's supposedly providing this intermediary function isn't intermediating in any sense of the word that a normal broker-dealer intermediates.
Right.
So it's going to be interesting to see how hard the SEC presses that part of the case, simply because those allegations come at the tail end of the complaint. They are they recognize that the wallet itself is non-custodial, so they don't have Coinbase doesn't have any access to or power over or discretion regarding the tokens that its end user has maintained, like using that wallet. And frankly, it's kind of hard for me to believe that Coinbase Wallet is a broker dealer if Google Chrome or some other software package or
Yeah.
like the interface on your Apple iPhone isn't also a broker dealer, because again, it's just a software package that
Yeah.
you're using to execute certain instructions that neither Apple nor Google nor Coinbase is interfering with or provide or facilitating in any meaningful sense. So it's going to be very interesting to see how that aspect of the case turns out. And that's obviously an aspect that it's paid a lot less attention to than the what happens to Coinbase, the exchange. But I think it's incredibly important for the peer-to-peer environment that part of the litigation be carefully watched and really vigorously litigated, because it has a huge impact on what software
Yeah.
developers like my company Consensus, who makes MetaMask, like what to what extent did the securities laws apply to anybody who's literally just making software to hand it to somebody to have them use on their own. The SEC obviously views their powers as like terrifyingly universal over these folks, and that's where their reasoning really falls flat, and hopefully the court in this case agrees with that.
Yeah. It sounds like an extremely weak argument from the SEC's standpoint. So the argument that I think is probably taking up quite a bit of time for litigators on the attorneys on both sides, is the staking piece and the operation of a unregistered securities exchange. Do you see either of those as being stronger? I have an opinion on which one I think Coinbase has a much stronger argument than the other, but do you see, are those in your mind equally as um, as crazy of a allegation as the wallet allegation, or are there tougher roads for
Yeah,
Coinbase on either of those buckets?
I think Coinbase is right on both. I can't really compare them against each other in terms of like handicapping the likelihood of Coinbase being right on one
Sure,
versus the other.
sure.
I think they're both novel cases. They're both obviously critical to get right, and will have ripple effects across crypto. And they really involve like different substantive issues on the Coinbase, whether it's a national securities exchange. That question really comes down to like whether a token itself
Yeah,
can be declared an investment contract. What the Ripple decision was about was whether the mechanism through which the token was distributed, whether that was an investment contract. In Terraform Labs, the court took a different approach. Judge Rakoff, who, let's say, is not shy about agreeing wholeheartedly with the SEC about their jurisdiction and how to interpret the law, he noted that it's not just the manner of issuance, but it's the whole scheme. It's just everything about the token. When you all roll it up into one, is it an investment contract? And then what is the investment contract? Oh, well, let's say the token is the investment contract. This is where like that reasoning starts to completely detach from any sort of logical if-then statement. It becomes a much more whole cloth, dare I say, results-oriented process to find the token to be the investment contract. But if these tokens are investment contracts and therefore are securities, all the SEC has to find is like that one of them is an investment contract. It all comes down to what this Howey test means.
yeah,
And whereas a district court may think it means X, we have an appellate process, and fundamentally, the higher up the ladder you go, especially the Supreme Court, I think would be inclined, if I was a betting person, to construe its past statements on the nature of the Howey test, its articulation of the Howey test. It would probably construe it pretty narrowly. Like the SEC has read out to the extent the Supreme Court has articulated a standard as being the Howey test, lower courts and the SEC has read out certain words in that test saying that word doesn't matter anymore. Like the word solely on the efforts of others, like certain courts in the SEC, it says, oh, well, they don't mean solely. Like, well, the Supreme Court said solely. So, okay. So I find that's the national securities exchange. I think that there's a lot of reason to believe that this very expansive view that you can just, there's no limiting principle around the thought process that gets you to a token itself as an investment contract, and therefore every token is a security. Coinbase's argument is that, well, tokens could be issued in a securities transaction, but that doesn't mean the token itself is a regulated security, and therefore the token is just a commodity because we have nothing to do with the issuance of them.
Right.
And I think that's probably the better of the two arguments. On the staking side, it really comes down to, are the efforts of Coinbase to offer this
product,
the staking product, are they of the nature of a securities issuer, or are they more technical services? Because the purpose of protocol staking is to ensure the data integrity of the network and to process new transactions. And you can either do that on your own or you can get help. You can outsource your node to a cloud computing service. You don't have to run a server in your house. Is a cloud computing service now a securities provider because they're providing you technical support?
Service, yeah.
The answer is like, well, clearly not. Well, what is Coinbase doing? Yes, they have custody of your token, but are they doing anything with the token that, aside from like running some applications for you that you pay them to run, and that you could do on your own, but you're outsourcing that administrative effort to them to make it easier on yourself? Is that more of a technical service, or is that really the type of effort that you associate more with the issuer of a security, where really whether you make income or not off of it is really predicated on all of what they're doing? Coinbase says it's technical services. What are you talking about? SEC says, well, if you do any effort whatsoever,
Wow,
and the person's expecting some sort of profit as a result, and they have to put up money or something of value to participate, oh, then it's a security. So I think it's a different question, and I think Coinbase's arguments are just as strong as they are in the prior case with respect to the National Securities Exchange.
Yeah, I've read several summaries on this, and your explanation was on point, very succinct. So glad for the listeners to be able to digest it in that way. And it sounds like the arguments are sound. I know Coinbase has assembled an extremely talented legal team. The SEC is taking blow after blow over the last couple months in the courts, and so things are looking promising. I'll just say that. And it sounds like what I'm hearing from you is, even if there were to be a setback, the higher up you go into the appeals process, and if you make it to the Supreme Court, there is less deference to the SEC at those levels typically. Is that generally what I'm hearing?
I think there are jurisprudential standards as to like when and how much deference you lend to a particular agency's expertise, both as to a technical subject matter, but also as to like how to construe congressional statutes which impact that agency's own regulations, that agency's own guidance. Mm-hmm. That said, it's the purpose of appeals courts to really the standards that they apply to really like second guess district court determinations as to facts and like the smaller details of a case. Like they really don't do that. What they really care about, like these major questions of law, where what the law means generally, and including what the law means in a specific circumstance, whether and how it applies, is really more what appellate courts are there to work out, because when they decide something, a lot more courts have to listen to them, and it's supposed to like, advance the whole jurisprudential waterfront a little bit farther. and that's certainly true with the Supreme Court. Whether a particular circuit, the Second Circuit, which is New York and its surrounding environment, or the Ninth Circuit or the DC Circuit is particularly deferential to the SEC. I think different judges have a different view as to how much credit you should be affording the arguments of an administrative agency. Like, for example, the Fifth Circuit, which is famous for, which Texas and other states are famous for, has, everything else being equal, has been relatively skeptical about a lot of agency announcements and pronouncements about the nature of their own powers, about their ability to do X, Y, and Z when it's not clear that they actually have such authority. Administrative excess is something the Fifth Circuit has been pretty hostile to. Not in every single situation, but more often than not, it's more, if you have a problem with agency action, the Fifth Circuit's a better place to be than the Second Circuit, the DC Circuit, the Ninth Circuit. So where you raise these issues, I think, can meaningfully affect perhaps the outcome. It doesn't determine the outcome. And what really, more than anything, affects the case is like the actual facts and circumstances and the law that's being argued. And I think this is where, I think in the Coinbase case and in some other cases, they're favorable circumstances. I think the Binance case, much less favorable.
Right.
The Terraform Labs case, much less favorable. When there's been a huge calamity and the defendant is responsible, or there's a lot of smoke in the air, there's a lot of allegations of like not only serious civil misdeeds but criminal misdeeds that are scattered throughout the complaint, like in the Binance case, like that's a rough case. And but the Coinbase case is not that. Coinbase is a good actor. Coinbase has been responsible. They've been forthright. They've been bending over backwards to make things work and to be reasonable. They've done everything right. And I'm very glad that if anyone's going to be hauled onto the carpet, it's them, because they got the resources and the expertise to fight back. And that's certainly what they're doing.
Yeah, I thought that as well. I mean, the Ripple case, in my opinion, our industry didn't have our best foot forward with Ripple or with Binance, but with Coinbase, we certainly do. And so I'm, excited about the outcomes there and getting more information. Also excited about the recent ruling with Grayscale. DCG, a subsidiary, gets a favorable ruling. What was that, yesterday or the day before? I think it was yesterday.
It was Tuesday. I don't, these days, I don't
who knows
even
what day it is even today that we're recording this. Yeah. So Tuesday, August 29th, I think.
Yes.
We see this Grayscale ruling come down, and this is a 3-judge appeals court, if I'm not mistaken. And tell us a little bit about, so I think everybody's probably read that the SEC is going to have to go back to the drawing board on their, rejection of this spot Bitcoin ETF application and come up with new reasons if they can. If they choose to, I guess they could just choose to approve it at any point. 45 days from now is when they have to make a determination, from what I understand. You can correct me if I'm wrong. And tell us what that means in conjunction with the BlackRock application. Do you think that there were people at BlackRock that were reading the tea leaves on this case, or do you think that they were just fortunate in their timing their application to for their spot ETF?
So it is a big case for a number of reasons. I think the chief judge of the DC Circuit was the author of the decision, and so in these panels, you have 3 appellate judges because a case has to be decided one way or another. You have 2-1 or you have 3-0. That's the only way it shakes out. So,
right.
if it had been 2-1, I'm sorry?
Do we get 3-0 in this case?
We did get 3-0. So if it was 2-1, you generally have the judge who disagrees write a dissenting opinion, essentially expressing how the court should have found for the other way. So if you had had that in this situation, you would have gotten an argument as to why the SEC was right about what they did was not arbitrary and, just evidence of their own caprice and making it up as they go along. They not only were they 3-0, but on every single substantive point, the court disagreed with the SEC's argument.
Wow.
So the argument in this case, to the extent you weren't someone wasn't paying attention, is spot ETFs and Bitcoin have been proposed for a while, and the SEC needs to approve these before they're traded on an exchange. They've been rejected for years and years and years. BTC futures exchange traded products had been approved. And it didn't quite make sense why a Bitcoin futures product would be allowed and a Bitcoin spot wouldn't be. The argument was that there were mechanisms to ensure that fraud and manipulation wouldn't happen with regard to the Bitcoin futures product, but the applicant couldn't prove that their product was safeguarded from fraud and manipulation. I think part of what was going on is like the Bitcoin futures product is literally only trading contracts on an exchange in the United States, whereas Bitcoin's traded all over the world, like
Right.
in every possible exchange you could, structure and location imaginable. And somehow this distinction was really important to the SEC. In any event, the SEC's reasoning in each one of these instances, like it didn't make sense because it fell apart when you actually compared the two products. This distinction that you could safeguard one and not the other really didn't make sense because the two were very closely tethered. You couldn't mess with one without messing with the other, so this case really established that this distinction the SEC is making makes utterly no sense. The showing that the SEC is demanding that these applicants make is unreasonable, and that essentially you need to go back and consider this applicant, like this product again, and this cannot be the reason. Or
Are
if it
there
is the
other
reason,
reasons?
you need to provide more reason why this actually, the reasons you have given so far as to why this distinction makes a difference are insufficient as a matter of law. You need to do more with this reason, or you need to come up with other reasons. And they don't really say, they don't give them the roadmap that far, but the point is like this, what you've been doing so far is just insufficient as a matter of law. The United States Code, specifically the Administrative Procedures Act, requires more of you. You're acting unlawfully. So go back and do it again. And we'll see what they do. They've stuck, if they have another imaginative way to shoot down this product, there's going to be more lawsuits. With respect to BlackRock, I mean, it's probable, I would imagine the folks, I mean, BlackRock puts out 1 billion products all the time. Other than Larry Fink talking about this one, it's not like, I would doubt that it's other than a very small group of people like actually working on it, but I would imagine that they would have done some legal work on it, and they would have seen what the landscape is, and they would have seen this as an important thing to do at this time if, after having received some sort of made some sort of determination on the merits of the legal case. But I would imagine they would have looked at the case and probably came to the same conclusion that the DC Circuit did with respect to the merits of it. And but look, there are a lot of these exchange traded products. When this whole shameful mess resolves itself and an exchange traded product actually shows up, there are probably going to be lots of them.
Yeah.
Because why play favorites with any one of them?
Right.
What that does to the market, Who knows? I'm not an expert in that, but I do think it is a remarkable repudiation of what has been an embarrassingly obstinate SEC on this issue, in the face of a world which is long since disposed of this issue as a problem. Like
Right.
everybody else has made products like this. It is just the SEC who has a problem with it. You know, to suspect it's symptomatic of a greater animus that is just sort of soaked into the bones of the SEC to crypto, I think is a fair thing to draw from it. And it's just certainly consistent with everything else we're seeing from the SEC. But
That's a
this
great
is why
quote, by
we
the
have a
way.
court system in this country. This is why we have a court system in this country. And thank God for the good people in crypto to actually stick up for the ecosystem and stick up for what they're doing and not lay down like people in TradFi are all too happy to do under most circumstances when the SEC says no.
I'm going to pull that quote that you said a few seconds ago. Something about ingrained in the bones of. I mean, it was great. That'll be sort of our that. Sohail, let's make that our intro into this conversation. That was a great
Welcome to
quote.
it. You're welcome
Um,
to it.
okay, so my prediction is that the combination of this court ruling and the BlackRock application and all the momentum that we will get a spot ETF approval, several approvals. Like you said, they're all going to come at once. I think it's going to happen this year. I don't know if you're in the game of making predictions, but
I don't, I mean, this is more of a test of whether the SEC is going to be able to take a different position on these issues or is just going to ride into the maelstrom, um, and not ask like what the consequences are for just ignoring every single sign that they are on the wrong side of this issue. If they're going to stick to their guns, I find it, even though that's what they've been doing so far, it certainly is a good pivot point for them where they could save a little face, say that, well, we disagree, but we're going to, adhere to the rule of law and we're going to listen to the court and respect its decision and we're not going to fight this anymore. And we've expressed our reservations. And there are some others, people who I respect very much who have who sort of have proposed that as like a likely way out, but it's certainly possible. I can't say probable or improbable, but certainly possible that yes, by the end of the year we do see that. And I think, it will be the first, I think, in perhaps a long line of exchange traded products tethered to particular tokens. And I don't view that as a particularly good thing or bad thing. I think with Bitcoin, just because it's so different, like it's a good thing. Ethereum, the whole idea of an Ether token is it's meant to be used to run this world computer. So it's like I think it's an investable asset second than something that's very important to like the actual internal functioning of of a world computer. And a lot of other tokens are like that, but some aren't.
yeah,
And so, to the extent that this is a class of investable assets, at least in part, I think you'll see more of these, and I think that's a good thing. And hopefully, this engenders more interest, more familiarity, and more people wanting to ask more questions about it and get more involved and participate in these ecosystems more.
absolutely. Well, we're excited about it and excited for the future. Really appreciate the breakdown that you've given us here, and the audience, I think, is going to appreciate it as well. Where can they go to find out more about you and more about
Sure.
Consensus?
So I am at Bill Hughes DC on Twitter. I will still call it Twitter. I will always call it Twitter.
Right. Me too.
Consensus.io is our website. MetaMask.io is the product site for MetaMask. We are, our principal place of business is in Fort Worth, Texas. We're very much looking forward to the summit coming up. hope to get a number of people down there. We're going to be participating not only in the summit, but doing some things on the side. We are starting meetups and community events in and around the Fort Worth and Dallas areas, especially because, Texas is a big Bitcoin state, and that's great. We know that there's an Ethereum community and a programmable blockchain community there that's growing. And I think it's great for Texas to have both.
Absolutely.
And we look forward to working with the Texas Blockchain Council and everyone else in Texas to solidify our roots in the state. We've been there since March, and very excited to continue to expand our community footprint in what is, by every measure, a very exciting, forward-leaning state when it comes to crypto. So that's why we're there, and that's why we're excited to be there.
Love to hear it. I'm going to cut that quote too. Bill, thanks for joining us. Your expertise is unmatched. I know a lot of people listen to you on other podcasts, and now they can get some of that expertise here on the Texas Blockcast. So thanks for joining us.
Happy to be here. I'll be happy to come back anytime. Good to see you.
Thanks.
Hey, it's Amy. Click over here to subscribe, click over here for more content, and we'll see you next time.